Hello, everybody, and welcome. My name is Dana Sparks. I am the broker of Maximum One Greater Atlanta and the director of the Real Estate Academy of America, which is the school offering this course for CE credit. So I hope y'all are as excited as I am to get this sneak peek of the changes that the Georgia Association of Realtors has made to their contract package for 2026. I am recording this on December 9th, 2025. So I'm going to share my screen and just get started. We have a lot of information to cover and can't wait to hear your thoughts. I also just pray that your time here is well spent. And I always pray to be a reflection of God's goodness, peace, provision, and protection. And I pray that this information will bless you so that in turn, moving forward in 2026, you too can be a blessing to your clients, your customers, your brokers, and your colleagues. So welcome, everybody. Again, my name is Dana Sparks. This class is the 2026 GAR Contract Changes. Beginning next year, probably March, we will teach an entire contract dissection class. Today's class is merely covering the changes. It is hosted by Maximum One Companies. You can get information there. I am the instructor. This class does offer both salesperson CE credit and broker CE credit. So those of you with a broker license will be very excited about that. The notice to students is, again, the school we have to renew at the end of next year. Course number 79227. It is approved for an in-class virtual CE credit. I'm the instructor. No homework, no written exam. The way we do attendance is via the chat function. So I will ask you 3 times. When you first come on, if you've already done so, you do not need to do it again. But when you first come on, I need your name, your license number, your email, and your phone number. When you come back from break, as well as before you leave. Additionally, I will ask you questions. Some will be rhetorical. Some I will prompt you to put your answer in the chat. Even if we have a lot of people on, so even if I have already given the answer, go ahead and type your answer in the chat. That way we can demonstrate that you were actually here and paying attention. But I'm so lucky because this class really is one that people want the information. So I know you guys are all here because you want to be here. And no recruiting. If so, let GAR know, GREC know, or myself, or Heidi Kelly is the coordinator of our school, and CE credits will be recorded within 3 to 5 business days. All right, we are diving in. I've got lots of drinks and we will take a break, but we are going to get started. Let's get this party started. All right. If you do not belong to a local board of realtors, then you do not belong to GAR, Georgia Association of Realtors. If you want to purchase the contracts for 2026, it is $349, one-time fee for the annual use. They will be available January 1st, wherever it is you get your contracts, whether that be Remind Docs, Transaction Desk, Dot Loop, wherever it is, January 1st is when they are available. Once the 2026 forms are released, it is a licensing violation from GAR to only use the GAR forms that are the current forms, the 2026 forms. If you use forms from any previous state, so those of you that have, some of you guys download the contracts on your computer. If you use previous dated forms after 1/1/26, GAR may revoke your or your broker's license to use them. Who else can use them? Well, again, if you are a realtor, meaning if you've paid your local dues and you are in good standing, then you get access to the GAR forms for no additional cost. It's part of your dues, but you must be in good standing with GAR and NAR. And for those of you realtors, just while I'm here, there is an additional training you must take, not only your ethics requirement, but a fair housing training. The current cycle ends the end of 2027. If you are not, you pay the GAR for the contracts and you will get an FPID number. If you pay for them now, keep that number. And then in January, again, like through Remind Docs or whatever, you will be prompted to either put in that FPID number or your NRDS number. Alternatives are if you are a co-op in a transaction, meaning if it is your signature on the signature page, then you also are entitled to use them per GAR's licensing agreement. But how do you get them? Well, you can only get them from the co-op agent. A broker may not give you blank forms to use, but if your broker does have access to them, your broker can use them even in your transaction, because we know all transactions are broker transactions. So if your broker's signature is on a form, then your broker can use it even in your transaction. And there are 2 websites for more information. Also, just if you are a realtor, there is a GAR legal helpline. And again, that is available on GAR's website. You do need an NRDS number. And again, this is just information where you can get that. While we're here, I have a handout. It is not required, but it is available. But I am going to, on my computer, I am going to put it in the chat so you can download it. And it is handout package. There we go. It is coming to you in the chat. It is a PDF and you can download it. The handout is all of these slides as well as the new forms for 2026. All right. The GAR forms changes. How do you know what they are? Well, GAR publishes an index of the changes, and imagine that. It is called 2026 GAR form changes. Remember, middle of the year, around springtime, to check the indices, because that's when they put out their mid-year changes. I have a YouTube channel, Real Estate Made Crystal Clear, and I do videos on all the changes. I'm in the process of doing them on the January changes, and mid-year, I will do the mid-year changes as well. If in your practice you come across something and you're like, wow, I really wish that was in the form, or ooh, this is bad in the form. I don't like this. This doesn't work. You are always welcome to reach out to the Georgia Association of Realtors with questions or suggestions, and there is the email. And now, what you've all been waiting for, let's dive in. Let's tackle and address the changes that the Georgia Association of Realtors has made for 2026. I want to thank Mike Nelson. Many of the following slides are courtesy of his presentation he did give December 1st through GAR at the 2026 GAR Contracts Train the Trainer class. That's the class that GAR provides for CE instructors, brokers, and school directors, so that we can learn about them and then turn around and teach our own classes. I do have his express permission to use the slides to teach. So they're not all his, but a lot of them are. So thank you so much, Mike. All right, as I mentioned, there is an index of all of the changes that GAR made. And wherever it is that you access your forms, whether it's Remind or Transaction Desk or Dot Loop, wherever you go to get a purchase and sale agreement or an exhibit or an amendment, if you look, you can get a table of contents and an index and all the special stipulations and this form. You don't have to do that right now because it is included in your handout, but it's just nice. Some people like to go and actually see what all the changes are. It looks like a lot. Some of it is a lot, but some of it is just they had to change paragraph numbers, or there's a lot of capitalizations and things like that. So, but I just wanted to show you what those are. As an overview, there are 6 new forms this year, 6 new forms, 1 new special stipulation, and 1 special stip that was deleted. Additionally, there are a lot of universal changes. The 6 new forms are, and I do have copies of these in the handouts, and we will cover these in this presentation. Ooh, this first one, can't wait to hear what y'all think about this. Exclusive co-listing seller brokerage engagement agreement. Unsafe property disclosure and hold harmless agreement. Buying property sight unseen disclosure and waiver. Holders notice to all parties. Exclusive commercial tenant buyer brokerage engagement agreement. Commercial purchase and sale agreement exhibit B4. The special stip that was eliminated is no commission owed by the buyer. Thank you, GAR, for protecting agents. And a new special stip is a walkthrough list. What's that all about? All right. Many, many universal changes. I am going to cover the broad, general universal changes first, and then there are some specific ones. So, generally speaking, in any form that referenced a statute of limitations, it got modified to 1 year. GAR had already changed that in the purchase and sale from 2 years to 1 year several years ago, and now it's just every form is consistent with that provision. Throughout every form, the term commission has been changed to compensation. Paying has been changed to offering. And GAR has capitalized all defined terms. For example, notice, buyer's broker, seller's broker, banking days, etc. Notices with the plural is now notice. And in the date field, instead of saying blank day of 20 blank, it is now just a single line for the date. So you can write out the date however you want to. I'm going to spend some time covering these specific universal changes. So when I say universal, it means everywhere protected period is addressed in a form, it got modified. But it's modified a little differently depending upon the form. So it was modified in the brokerage and customer agreements. Warranty was modified in the purchase and sale and option agreement. Right to extend closing date. That's the 8-day unilateral. That was addressed. Big changes to that. That was addressed, changed in all the purchase and sale and option agreements. Holder of earnest money. Oops, I got a spelling mistake. Changed in the purchase and sale agreements. Agency disclosure changed in those agreements. Disclaimer in the purchase and sale and option. Entire agreement paragraph changed in the purchase and sale and option. Property delivered in clean condition, no more broom swept. That was changed in purchase and sale. Instructions to seller in completing this agreement, that was changed in the disclosure, property disclosure. How this statement should be used by the buyer. So instructions to the buyers and the sellers in the property disclosure statements have been changed. Financing contingency change, just a minor change in all the financing exhibits. Master insurance policy special approval. Ooh, this is going to be a huge issue in 26. As a broker, I have dealt with this 3 times in the past month. So I'll get to that. I'll speak more specifically to that when we get to that part. And you guys are going to love this. In the financing exhibits, they talked a little bit more about the loan denial letter, and they changed the seller's right to request evidence of ability to close. So I'm going to dive a little bit more in. This is in the exclusive seller brokerage agreement, the protected period. What they changed is they just added a lot of what GAR did this year is they try to do this every year, but what they have done is they really try to clarify the language, still make it legal to protect everybody, but they try to make it more understandable so that agents can explain the contracts a little better to their clients and customers. Agents understand it better, and specifically so the public truly understands what it is they are signing when they sign these forms. So they do this. This is their goal every year. So under the protected period, they added at the bottom, for all purposes herein, showing property to buyers virtually shall include showing the buyer's property by video or sending a video tour to the property to the buyers. So again, they've just added language defining really what virtual showings is. In the non-exclusive seller brokerage agreement, they've changed it a little bit because this is when a seller signs a non-exclusive brokerage agreement, has a client relationship with more than one broker, which on one hand is great, on the other hand can get a little bit messy. So basically what they have done is the issue could be, well, which broker gets paid? Which broker can demonstrate that they are the ones that deserve the commission should the property go under contract? So a lot of this verbiage has been changed. Again, I'm not reading it word for word, but you can see what the 2025 version is, and that's been marked out with the black mark throughs, and the blue is what's showing what the changes are. This part is not changing the content. It's just reads a little bit easier. And just like on the exclusive agreement, they say that you must have shown the buyer. So actually, let me go back up here a little bit. It says, no, it's saying that you must, let me see this one. You must have shown the buyer. In the exclusive, it says you must have shown the buyer in person or virtually, or provided information to either directly or through a broker working with the buyer. In the non-exclusive, you must have shown the buyer. That's the difference between just giving information. That's the big difference between the non-exclusive seller brokerage and the exclusive. And this information here, this is the same as in the exclusive. Again, they just made it read a little bit easier, that there's no protection. Agents, this has always been the case. There's no protection for your commission if you mutually terminate a brokerage agreement. Then there is no protection. All right. Or, well, anyway, I'm going to teach that in the other class. This is the authorization to show unlisted property. So this is the document that describes the customer relationship between your broker and a seller who has not signed a brokerage agreement. And again, they just made this easier to understand. So they made it easier to understand. And at the bottom here, accidentally, they had verbiage that never should have been here. It had verbiage that referenced, you can see what's marked out. It had verbiage that referenced an exclusive that they copied and pasted basically from the actual brokerage agreements to the authorization to show unlisted property. So they got rid of that language that never should have been here and referenced owner instead of seller and just made it easier to understand. No true changes to the content of what the form is. Again, we're still talking about protected period. Now on the buy side, they changed it. They just said, yes, F107 would be if you're showing for sale by owner or any seller who doesn't want the client relationship. Just it by default, if a seller or a buyer does not sign a brokerage agreement in Georgia, they are your customer. GAR has forms that describe that relationship so everybody is on the same page, and it accounts for compensation too. Time broker may be entitled under certain circumstances. Excuse me. Again, it's just clarifying when the protection period kicks in. That's in section A. And again, they're still filling the blank for the number of days. And it is just clarifying language to make it easier to understand. They talked in circles and it's just easier to understand, but no true content changes. All right, in the warranty paragraph, in all of these forms referenced above, all they did was add, this is the seller warrants that at the time of closing what they'll convey, good and marketable title, subject to zoning, and these various easements and improvements. And they put other than driveway, they've added wall, fence, mailbox. Usually GAR adds things specific like this when there were issues. So either a lot of agents had issues and petitioned GAR to add them into the contracts, or there were lawsuits and various judgments or decisions that came down. But usually those are the main reasons why GAR adds, especially something specific like this to our forms. Okay. Lots and lots of changes to the 8-day unilateral extension. Last year in January, they added an 8 p.m. deadline, and I used to teach 8 by 8. The party using the 8-day unilateral extension had to send it prior to 8 p.m. day of closing. They removed that. Also, it used to read where there were the specific reasons are still there. Title issue, as long as it can't be satisfied. Well, I'll read it to you in a second. Title issues, closing attorney scheduling issues, or lender issues. It used to be that any party could use the 8-day unilateral for any reason. For example, if a seller wanted to keep a buyer in contract and their loan was hung up in underwriting, the seller in the past could initiate the 8-day unilateral extension to keep the buyer in contract. Starting in 2026, you need to stay on, quote, your side of the tracks. Now, only a buyer may initiate an 8-day unilateral extension for mortgage lender delays not caused by the buyer. Only the seller may initiate the 8-day unilateral extension for title delays that may not be resolved by paying money or prevent the seller from conveying good and marketable title or an attorney delay not caused by the seller. Those are the differences. What is the same? It may only be used one time per contract, and the party exercising the extension must do so by notice. Here is how it reads. Buyer may unilaterally extend the closing date once for 8 days upon notice to the seller if either the buyer's mortgage lender, including where the financing contingency has expired or there is no financing contingency, or the closing attorney are delayed and cannot fulfill their respective obligations by the date of this closing, provided that the delay is not caused by the buyer and with respect only to an extension resulting from the closing attorney being delayed and the seller has not already unilaterally extended the closing date once for 8 days. Seller may unilaterally extend the closing date once for 8 days upon notice to the buyer if the seller cannot either satisfy valid title objections, excluding title objections that can be satisfied through the payment of money or bonding off of the same. In other words, if there's a lien on their house, and they're working that out, can't use the 8-day unilateral, or there's a title issue that does not prevent the seller from conveying good and marketable title as that term is defined herein, or the closing attorney is delayed and cannot fulfill its obligations by the date of closing, provided that the delay is not caused by the seller, and with respect only to an extension resulting from the closing attorney being delayed, the buyer has not already unilaterally extended it for 8 days. So the closing attorney can be used on either side, but again, you can only use it one time. That's a big change. All right. Moving along to the holder of the earnest money. This has been addressed in all of these purchase and sale agreements referenced above, including the option. And basically what it says is, it says the fact that the holder may represent one of the parties in this transaction as a client or is working with such party as a customer is acknowledged by all parties and shall not be the basis for the holder not performing any of its duties hereunder, including but not limited to dispersing the earnest money based on a reasonable interpretation. So sometimes if there is a dispute, if there's a termination and a dispute over who gets the earnest money, the holder, one of the things a holder can do is interpret the contract and disperse the money to one of the parties. What this is saying is, okay, holder, obviously you're working with one side of the transaction or the other. That's not an excuse to not do your duties. That's a given. So this is sort of an admonition to the holders. Holders, you can't get out of doing a 10-day letter or doing your duties because you're working with one side. That's pretty obvious. And it's an admonition or a disclosure to the parties, the public people. Hey, the holder of the earnest money is working with one side or the other. However, they still have to perform their duties as holder as outlined in the purchase and sale agreement and in the case of a broker per license law. Additionally, we have a lot of foreign investors investing in real estate, and they've added that any money, any checks or ACHs, basically any money in a transaction, must be drawn upon an account in a financial institution located in the United States. And again, some of these other things, like I said, they capitalize banking days and notice. So again, I just have added that the holder must perform their duties even though they are representing one side or the other and must be a U.S. bank. In the agency disclosure, okay, agents, you guys all know this or should know it. But as a real estate agent in Georgia, you do not have a fiduciary responsibility to your clients. Not in Georgia. And so this is just disclosing that to the public. Again, making it clear. No broker shall owe a fiduciary duty or other duty. And basically, it is just a reminder. It's a disclosure to the public and a reminder to you as an agent that per Beretta, agents in Georgia act as an intermediary with defined responsibilities and not traditional fiduciary responsibilities. What are those defined responsibilities? Well, it's spelled out in the contract. Shall know of no broker, and by extension, that means you, an affiliated licensee, shall owe a fiduciary responsibility or any other duty to the buyer or seller greater than what is set forth in their brokerage engagement and in our Beretta laws in Georgia. Those are the defined responsibilities. The disclaimer paragraph. This has been addressed again in all of those documents referenced at top. And it is, again, the language has just been modified for clarity, to make it flow better so that the public understands what they are doing. And this is as a broker, this is one of my favorite paragraphs to protect brokers and you guys as agents. And I'm not going to read the whole thing, but just the gist of it is buyer and seller have not relied on any promises, statements, or representations. It used to just say representations. They've added in whatever you as an agent put in writing or promise or say, and collectively it's called representations of brokers, other than what is included in this agreement. And I can't tell you how many times I have taught agent to agent communication has no bearing on the contract with respect to binding the public buyer and the public seller to terms. The problem is you guys rely on each other and the public relies on that. This statement right here says, no, you cannot do it. There's other verbiage throughout the contract that says that as well. But it is just clarifying that, and they added in promises or statements, and they've added some specific things in. They added in termites, moisture, and above tests and inspections. Again, it just flows a little bit better, but this is a very, very important statement. And again, they added promises, statements, and reference other sources of resources or tests that the public does. And basically, and the other thing they've done is they've added amendments. This is a key right here too. So this was just in the purchase and sale agreements, this disclaimer, and they've added amendments. So it says, okay, public, not only can you not rely on any promises, statements, or representations of the broker or agent with respect to the purchase and sale agreement, but any amendments that get added later. So that's a key provision that they have added. Under the entire agreement paragraph, and again, this is addressed in those forms up top, they have just added in that it shall be solely the entire agreement is here in writing, and that it has to do not only with the purchase and sale agreement, but any other documents that are referenced. And there is a spelling error right there, reference, that will be corrected. All right, moving on. Property to be delivered in clean condition. What they have added is they have added that even though it's resale, some of our resales are getting remodeled. And so there are construction materials that are even in our resale purchase and sale agreements or houses. And they have added that, I'll just read the whole thing. Notwithstanding any other provision to the contrary, at the time of possession, sellers shall deliver the property in clean condition, free of trash, garbage, debris. They've added construction materials, pets, and personal property. They added pets last year. You guys, that is so horrible to me that somebody would leave a pet. Is that they added that in 2025, and the fact that they had to add that is just, that's horrifying to me, that somebody would just leave a pet. But regardless, construction materials, pets, and personal property of the seller not otherwise identified in this agreement as remaining with the property. So again, they reference in the agreement. They're trying to make sure that everybody understands everything regarding the transaction for a buyer to buy a house and a seller to sell a house or land or so forth and so on must be contained in the contract. Any emails, agent to agent communication regarding, oh, well, they'll take the flowers. Oh, they're digging up the flowers. They're taking the outdoor furniture. Well, they're leaving the swing set. That has to be identified in the agreement. So they're adding in the agreement. They've added construction materials. It does say firewood, however, shall not be considered debris. Obviously, there was some issue with that. Yeah, that's a good question. So there's a good question in the chat. Uh, uh, is someone now going to fuss because of paint, tiles, shingles, etc. being left or not left? That is now considered construction material. That is a great question, Beth, and I don't know. Those of you experienced agents know the more specific you can be in a contract, the better. So that might be something you want to add in, have your sellers add in, or your buyers add in the seller property disclosure statement. So that's a good question. I don't know how that will be defined. Does this mean if there is an as-is special stip, need to leave it clean? So this has, that's an interesting question, Jody. This has always been in the contracts, the broom swept condition clean, not always, but years and years and years and years and years. So even a seller selling a property as is, this paragraph has been in there. It still had to have been left in broom swept or clean condition, free of trash, garbage, and debris. As is really implies that the seller is not going to make any repairs of anything. But again, if you think that is going to be a point of discussion, notice I didn't say contention, I said discussion. If you think that is going to be a point of discussion in a contract, where you're representing either a buyer or a seller buying a property as is, I would specifically address it in the contract. You know, you might have an investor buying a property and they don't care. They're going to bring in a crew and totally remodel everything anyway. So I'm taking some notes to see if I can find out. So thank you guys. Construction materials, paint, tiles, and as is and clean. All right. Awesome. Awesome discussion. All right. Let's see. I've got a couple other. Always specify expectations. Yes. McKay is giving us great advice. The more specific you can be in a purchase and sale agreement to clarify everything in advance, nothing is an issue until it's an issue. I teach that all the time for you guys as agents and having to deal with contracts. But the same applies to you. You guys should have this in your mind too. When you are working with your buyers and your sellers, don't leave anything up to interpretation. Don't make, nothing's an issue till it's an issue. Everybody's all happy, woo, 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 yay, yay, lovey, lovey, so excited, till you do a walkthrough and you're like, I thought they were leaving that paint because there needs to be touch up. Well, they took it. Well, can they take it? Or they took down the curtains, but they left the brackets. Or they patched the hole they left in the wall when taking down the brackets, but it does not look great. You guys, you need to address these what ifs as much as possible before it is an issue. Okay, a lot of investors have a special stip that if stuff is left, there's a $5,000 fee. Had a seller leave their cat and asked me to find it a home. Wow. Wonderful realtor showing it rescued it. Yeah, that's just a wow. All right. Oh, Bobby, perfect. I'm going to adopt this and use it. When in doubt, spell it out. I love that. Nothing's an issue till it's an issue. But this is my next new catchphrase attributed to Bobby Poole. When in doubt, spell it out. Woo! Love it. All right, let's move on. All right, these are the disclosure, all the disclosure forms. Instructions to the seller in completing this statement. Again, they've just tried to make it more English sounding rather than legalese sounding. So everyone did not have to go to law school to try to understand all the language. They got rid of thereon. Answer all questions in reference to the property and the improvements thereon. They just put on the property. So that's what I mean in general throughout these forms when I talk about making it more clarifying the language. And then promptly revise the statement. They've added if prior to closing there are any material changes, seller shall promptly revise the statement. Again, they just simplified the language and how these property disclosure forms should be used to the buyer. A few years ago, GAR took out the check column for don't know. They just have a yes or a no. Well, that is still sort of causing some potential confusion. So GAR is still trying to clarify that. And they've just added, again, instructions for the buyer. A yes or no answer to a question means yes or no to the actual knowledge and belief of all sellers of the property. In other words, if a seller answers no to a question, it means either the seller affirmatively knows that the answer to the question is no, or has no knowledge of whether the condition exists. So again, that's been problematic because a lot of buyers, if a seller has put no, they take it as a no, meaning no, it's not an issue. GAR says it could be they have no knowledge. So there could be an issue there, but the seller does not know. But they just previously had said no knowledge. GAR added means the answer is definitely no or no knowledge regarding and seller answer should not be taken as a warranty or guarantee of the actual condition of the property, nor a substitute of the buyer doing their own due diligence. All right, there's more changes to the disclosure forms that I'll get to generally. Again, these are just specific changes that apply to multiple forms. Okay. Love this. In all your financing contingency exhibits, it basically states this is not different. The content of this is not different. That the buyer has the time frame to get a lender, to convince a lender to lend them the money. If not, then they have to terminate within that time frame, and then they've got 7 days later to prove it with a loan denial letter from the lender. That had always been in there. What they added is on that loan denial letter, it must state the basis for the denial of the loan. It can't just be a form letter that says we're denying your loan. It must state the reason. Why? Because depending upon the reason, other parts of these financing contingency forms kick in. So I love that they've added that. And then this one is just a spelling correction. Again, I have on here, it seems obvious, but it is very, very important that the reason be on there because there are certain reasons for denial that protect a buyer's earnest money and certain reasons for denial that do not meet the terms of the GAR financing contingencies. This special approval if the property is subject to if the property is a condominium or subject to a master insurance policy. I'm going to spend just a skosh bit of time on here. The change that GAR made. Let me talk about let me address the change GAR made and why, and then I'm going to talk just briefly about this. What it used to say at time of closing, they changed it to date of closing. Why? Well, date of closing they put in there because a buyer and a seller may actually sign their portion at different times. So if one of the parties signs their closing documents early or a couple days before, if it's a mail out or something like that, and the other party signs later, well, which one constitutes closing. So they've just changed it to the date of closing. I think that's a really, really good change. But just briefly, without reading this, and I'm not going to go into depth, I go into depth on this in my other class, and I've got to do a video on this. This has come up again 3 times within the past month. I had to deal with this last night for one of my agents. Basically, this provision, this paragraph, and GAR has added this. They added it last year as a special stipulation as well. But I don't think if there's no financing, I don't know, but it's in all the financing documents. But there are lots and lots of issues with insurance, getting insurance on a condo or attached properties. And one of the there's changes in all of the underwriting criteria. Basically, the insurance policies are increasing tremendously in prices and premium prices. And what's happening is a lot of the HOAs and associations are now, instead of paying the monthly premiums themselves, they're putting those premiums on all of the owners of the properties. Because of these 2 issues, it is making owning a condo where this is happening or buying a condo where this is happening cost prohibitive to a lot of people. And so, just so you guys understand, there is now, if you have a contract with a financing contingency, and this is spelled wrong up there, there is a third contingency. So there is the financing contingency, which is the buyer's ability to convince a lender to loan them the money. There is an appraisal contingency, and in FHA and VA, that's the amendatory clause. Is the property, if the lender had to get that property back and sell it, is the collateral sufficient enough to cover the money they lent out? Those 2 contingencies are in all the financing contingency exhibits. There is now a third contingency in all of these exhibits. And this, again, came in 2025, but it is just now becoming an issue as condos are renewing their insurance policies. But this third contingency is contingent upon the lender, not Fannie Mae, not Freddie Mac, not FHA, not VA, but a specific lender approving of this insurance policy. And the term for that in the contract is project approval. Some lenders are still loaning based on these insurance policies. Some are not. So again, I'm not going to go into any more detail about that, just to bring to your awareness this third contingency, and it goes through day of closing. Actually, yeah, through date of closing. That's the change they made, but very, very important if you are working with buyers and sellers in condos or attached properties. All right. And again, consistent with that previous paragraph, 2 paragraphs ago, they've just added that in the loan denial letter, they must state the basis for the loan denial. And this is the reason why, because if the loan denial is based solely on one of these issues, the buyer's going to lose their earnest money. They are not protected. That's why we have to know the reason. All right. Now, again, we're still in the financing contingency issues, and I'm so glad GAR changed this. It still might not work out, but this has been in here for several years. And basically what these 2 paragraphs say, I need to make this a little smaller so you can see the paragraph numbers, but what these paragraphs say is, we're past the financing contingency time frame. The buyer did not terminate. The buyer's in there. As soon as the financing contingency time frame has expired and the buyer did not terminate, the seller now has the right to ask the buyer to provide basically a loan commitment letter. It could still have conditions, and it's not proof of closing. We all know that. It's never closed until it is closed, until it is funded and your check has cleared the bank. But this has been in there. The problem with it, and so the seller has the right to ask the buyer for basically a loan commitment letter with the conditions. There's timeframes built in there. And if the buyer can't do that, then the seller has termination rights based on that. And the timeframes, they just shortened the timeframes. It used to say 7, they moved it to 5, and this used to say 3, they moved it to 2. The problem is, and this they're making an effort, is usually all of this stuff ran after closing anyway. So if you have, let's say you had a 14 or a 21 day financing contingency, and you have a 30-day closing, like from binding agreement date, 21 days for financing contingency, and basically you're closing 30 days or shortly thereafter. Well, 21 days goes by, and then the seller says, okay, I'm requesting your evidence of buyer's ability to close. The buyer had 7 days, and then if they didn't provide it, the buyer said, but when all these timeframes worked out, you're after the closing date anyway. So again, GAR has just shortened these timeframes to try to preserve the seller's termination rights should the buyer not provide this before the closing date. All right. Whew. That's really it for the financing exhibits. Okay, consumer brochures. They have corrected one, and they've added insurance on the other one. So the first one, what to consider when buying a home in a condo. It did have new construction language in here by accident, as I mentioned. GAR, like all of us, they copied and pasted from one brochure to another, and it accidentally had new construction language in here. And so they just took all of that out. And again, it references even, for example, here at the bottom, GAR new construction. And in what landlords need to know about leasing a property, it's just a reminder, hey, you guys, you need to check with your homeowner's insurance policy and make sure that you have coverage that extends for any vacancy periods, 30 days, 60 days, so forth and so on. So again, it's just a reminder to our public landlords. All right. We are going to move on into those were all the specific universal changes. We're going to move on now into the specific forms. So, seller brokerage engagement agreements. These are the changes they made. And again, some of them are just paragraph changes, but I'm going to cover the main issues. They have, in the marketing section, they've changed this verbiage to be consistent with the NAR changes. And a lot of the changes they've made are really important for, remember, this is Georgia Association of Realtors. These contracts go through all parts of Georgia. In other parts of Georgia, the MLS services are all completely owned and operated by various boards of realtors, and they operate very differently. Membership and listing and buying through those in other parts of Georgia are very different than they are here in Metro Georgia, where FMLS and Georgia MLS. Eddie, I think, excuse me one second. Eddie, that is just you, because I don't think anybody else is hearing any sound. So, but that's just a reminder that some of this stuff is like, well, we're already doing this. It doesn't make sense to us here. It definitely makes sense to people in another part of Georgia. So in the marketing section, they have added selection of multiple listing services, where you spell out what they are. Delivery of agreement and listing with an MLS. This has always been in there. This agreement shall be timely delivered to and listed with the above referenced multiple listing services in accordance with the rules of such multiple listing service. which may limit the availability and time duration of the marketing options below. This obligation and these limitations shall control over any conflicting language herein. Again, this also has to do with there have been lots and lots of ongoing lawsuits and decisions and rule changes with NAR regarding MLS services. Again, some of this stuff doesn't make sense to us here because of how FMLS and Georgia MLS operate for us here and brokers and you guys as agents. Marketing commencement date is still there. The paragraphs are a little different. And then all of this is new. And again, a lot of this just reflects what I've been talking about. But they've spelled it out to make it a little bit easier to understand. Coming soon. If offered by the MLS, seller directs or does not direct broker to file the property listing in the MLS listed above in coming soon status for blank number of days prior to the marketing commencement date, during which time the property will be visible to MLS participants as coming soon, but the property may not be shown to the public or purchased during this period. You guys, this has always been the case of a coming soon status as defined in FMLS and Georgia MLS membership rules, but this is just now spelled out, not only for the public, but for agents and brokers as well. At the end of this period, the property will be changed to active status and marketed to the public as set forth in Section A3 above. The maximum coming soon status period is set by the MLS. If the coming soon status period exceeds the maximum days permitted by MLS, then the MLS maximum shall control. MLS marketing options. With 1 business day of the marketing commencement date, the listing must be filed with the MLS listed above. Seller directs broker to market the property for sale using the multiple listing service options selected below. Select options shall apply. Either immediate public marketing option. This listing shall be immediately visible to MLS participants and may be electronically distributed through IDX or Internet Data Exchange so that the MLS participants can display it on their websites. The property may also be distributed through syndication to make it available to be viewed on various third-party sites such as Realtor.com, Zillow, or Homes.com. Such listings are considered to be active listings and the property may be shown to potential buyers. Delayed marketing exempt options. The listing will be immediately visible to MLS participants and may appear on the websites of brokers and brokers licensees. However, marketing of the property by other brokers through the IDX and syndication to third-party websites will be delayed for a period of blank number of days. During the delayed marketing exempt period, the listing will not appear on other brokers' websites or on websites like Realtor.com, Zillow, Homes.com. Such listings are considered active listings and the property may be shown to potential buyers. Office exclusive marketing option. The property will initially be marketed through an office exclusive period of, to fill in the blank, you have to put in the number of days, during which time the property listing will only be available to licensees affiliated with the broker during office exclusive marketing period. The property listing will be submitted to the MLS listed above. However, the listing will neither be marketed publicly nor disseminated through the MLS and will not be visible to other MLS participants. Such listings are considered to be active listings and the property may be shown to potential buyers. Disclaimer. By signing this agreement, seller understands and acknowledges that if the seller is delaying the public marketings of the property by selecting an office exclusive marketing option or delayed marketing exempt option, the seller may not maximize either the number of offers seller receives or the price offered to buy the property. Seller nevertheless knowingly waives the potential benefits of immediate public marketing. Woo. All right. And then because of that, there was a section about delayed marketing and they've just added it to that section above. Moving along. Okay. Oh, this one's a good one. All right, you listing agents. Again, this is in the listing agreements. Under the compensation section, we've had an issue. We've had it where sellers have said they're offering a certain amount of compensation, obviously to you, their listing broker, but a certain amount of compensation offered to a buyer's broker as well. Well, then we had some buyer's brokers that the buyer represented by the buyer's broker asked for an amount for the seller to compensate their broker that was lower than the amount the seller was willing to offer. What happens? So, if for 2026, GAR has added this sentence. If buyer or buyer's broker does not request or accept the full amount of compensation being offered by the seller's broker, if any, the remainder shall be an additional compensation to the seller's broker. So if buyer requests compensation for their broker less than what the seller has already agreed to pay in the seller brokerage agreement, then this overage goes to the seller's broker. All right, moving on. A new form. Exclusive co-listing seller brokerage engagement agreement. Most of the form is the same as the exclusive seller brokerage agreement. I'm just going to talk about the differences on the following slides. Brokers on here, again, this class is for Broker CE as well. Brokers, y'all may want to have a policy regarding this form, this situation, if you are going to allow it or not allow it. If you do allow it, who's going to sign this form? Check. And agents, check broker policy if your broker will even allow this. What are you talking about, Dana? This is a listing agreement that a public seller signs with two brokers, not two agents in the same brokerage, two separate brokers. And it says they are co-listing brokers. And basically, for and in consideration of mutual promises, the undersigned seller and undersigned co-listing brokers do hereby enter into this exclusive co-listing seller brokerage agreement. And it names broker number 1 and broker number 2. It goes on again. The rest of the form is the same. Under the compensation section, compensation to sellers brokers. So this part is the same. This part is the same. This first paragraph 5B. It's the total amount the seller is paying for the listing side of the transaction. Then this little section is new. How the seller's brokerage compensation will be shared between broker number 1 and broker number 2. Percentage of the seller's brokerage compensation to be paid to broker number 1 and percentage paid to broker number 2. So of this amount up here in A, what percent is, is it being split 50-50 between the two brokers? Is it being split 60-40, whatever? That's of the seller side commission. And I'm just pointing this out, in the separate compensation on a lease, GAR did not address this. So I have a feeling that's going to be changed either mid-year or next year. But if you are in this co-broker listing agreement, you will definitely need to specify if they end up doing a lease or a lease purchase. Again, how is the seller side, the listing side compensation being divvied up between the two listing brokers? Yeah, this says a good question. A percentage of this, why not an amount? Again, I think I would put an amount rather than, of this, because when you start doing percentages of percentages, oh, that's why they didn't do an amount, because if this is expressed as a percent, if the seller is paying a percent of the list price to to their brokers as compensation, you can't do a specific amount because you don't know what that's going to be. That's why they did it 1% of a percent. So, like, you know, if a house sells for 500,000 versus 450,000, and the sellers agreed to pay a certain percent of that, well, that dollar amount is going to vary. So if you put a specific dollar amount here, that might not match up to the total amount the seller has agreed to pay. That's why they didn't do a specific dollar amount. What is the max number of broker parties in a co-listing? 2. What if the seller wants to pay a flat amount of compensation? If the seller is paying a flat amount, then again, you could express this, you know, you could do that here. And again, it just gets divvied up between the two brokers. But let's move on. There's more to this form. What is each one of them doing? Because FMLS and Georgia MLS, and I imagine other MLSs throughout the state, will only allow one broker to have a listing in their MLS. They can't have one listing with two brokers. So what do you do? So, roles of each broker. Each of the brokers in the co-listing property agree to work together cooperatively to market and sell the property and to keep the other broker informed as to the activities in furtherance of that goal. The initial division of work between the two brokerage firms shall be set forth below. Directions for filling out division of labor. If a brokerage activity is checked below as being performed by just one, it means that the selected broker shall be responsible for performing that activity to the exclusion of the other broker. If a brokerage activity is identified as being performed by both, it shall mean that two brokers shall be jointly responsible for performing the activity together on behalf of the seller. I'm laughing because I'm reading y'all's comments. If a brokerage activity is being performed is by either, it shall mean that either broker, depending on who has been contacted regarding the activity or who is available to perform it, may perform the activity, and both brokers agree to try to share the work equitably. So there's a whole slew of things. Who's going to list it in the MLS service? See, this one, obviously, it can't be both. MLSs will not take a listing with two brokers. Who's going to put the lockbox? Who's going to put the sign? Who's going to develop the marketing materials, paying for marketing materials, staging the property, marketing the property if office exclusive marketing, showing the property, holding open houses, answering questions, holding earnest money, negotiating the contract, preparing counter offers, amendments, and other, attending inspections, attending closing, other. Performed by broker number 1, number 2, both, either. And this will be spelling, we'll correct it. The signature is signed obviously by the seller and broker number 1 and broker number 2. You brokers, if you do allow this, you need to have a policy. Are your agents allowed to sign this, or you as a broker? Is this going to be a form where your signature is going to be required? So again, just looking at your questions, this is a really interesting form. Brokers, you do not have to use it. You can have a policy prohibiting this type of situation. If you do use it, I'd be really interested to see how it works out. Both brokers get paid regardless of who brings the buyer. Yeah, or there's a third broker that brings the buyer. You know, just like any listing agreement, you have to have that discussion with the seller. They're still paying one pot of money to the listing side. It's just that listing side is getting divvied up between two brokers, and the seller may agree to pay compensation to a third broker representing the buyer. If one of the brokers brings the buyer, how does that get divvied up? So lots of questions, lots of issues. So why did this come about? One of the comments in the chat is there's a lot of reasons, but this is apparently a situation that does happen in commercial. And yeah, just skip this form and go to the next one. Yeah. There's other situations. I don't know. Again, this is really going to come down to broker policy. I'm just bringing your awareness that this is a new form. Check with your brokers. Brokers, this is going to be the great topic for sales meetings and discussions and interesting scenarios. Honestly, I don't really see it being used a lot. As a broker, I think it presents some issues. There are a lot of firms out there that have a broker side and a non-broker side that on paper are two completely separate companies. Nevertheless, the agents are in the same offices and same sales meetings. I can maybe see a situation where it is used in that scenario. But other than that, check with your broker. All right, moving on. Authorization to show unlisted property. So again, this is the document. So is this in lieu of a referral? Yeah, that the issue that I would do, and typically how it has been handled in the past before we move on, is usually there's just a broker to broker referral agreement. It could be that one agent has a relationship with a past client and they decide to sell their house, but it's not in an area that agent works in, or the agent really isn't that active anymore, but they still have an active license. And, but the public seller has the relationship with that one, but that agent really isn't comfortable listing it, so forth and so on. And typically how we've handled these situations in the past is with a broker to broker referral form, that the agent with the relationship with the public person refers it to somebody else, kind of stays involved. But I still think that's probably moving forward how these situations would still be addressed to avoid as many issues as possible. All right, I'm going to move on. Authorization to show unlisted property. The protection period was added to Section A, and fair housing. They didn't get rid of fair housing. They're never going to get rid of fair housing. They just moved it down to a different paragraph. Let's tackle the buyer brokerage agreements, and we will see what time it is after that. We will take a break in a little bit, but hang in there. So again, these are the changes. Protected period, again, we've already covered that in depth at the beginning of the presentation, and same thing in the non-exclusive, and agreement to work with buyer as a customer. So in the non-exclusive buyer brokerage agreement, they add where it talks about the limits on broker's authority. They've just added this limitation of liability shall survive the termination of the agreement. Agreement to work with buyer as customer on that form. Again, all those other changes I addressed at the beginning of the presentation. When compensation is due, again, they took out a lot of this confusing language to simplify it, and they just said buyers shall be obligated to pay buyer's broker the compensation reference above at the closing of any property that was shown to buyer's broker or buyer. Again, not identified. They've taken that out. You actually have to show the property. Even if the closing is after the expiration date, and they just clean that up rather than having all this legalese. Yeah, and also this reference buyer brokerage agreement. So they just took that out. Okay, leasing. This is the leasing management agreement. This is not the residential lease. This is the leasing management agreement. Lots and lots of changes to this form, but I'm just bringing them to your attention. The majority of agents do not do property management. A lot of you guys do. So if you do property management, these are extremely important. But again, I just want to bring to your attention the changes that GAR made. GAR really tackled some forms that they really had not tackled in the past. Lots and lots and lots of changes to this form. One of the biggest things they did to this exclusive leasing management agreement is they made it consistent with the changes they made to all the forms several years ago, where paragraph A is all the fill in the blanks and paragraph B is all the corresponding paragraphs. Prior to 2026, the fill in the blanks were spread throughout within the paragraph. So this is a good change just for consistency. And throughout, they made commission, changed it to compensation. Now what they've had, there were some property managers that had landlords they represented, and there was a situation where they would reach out, they needed a decision regarding the property. They had to do something regarding the property, and a property manager would reach out to the landlord and for approval of an application, and never heard from the landlord. And so they've added, if the owner does not respond timely within X number of days, the manager can now approve applicants. In other places now allows for automatic renewals. Section B includes auto renewal language. There is a new state law, OCGA 1312.3, that requires new language for automatic renewals of leases and property, really leases. And they clarified this, that clarifies when the monthly fee for serving as an escrow agent applies. Management fee is now a % of the amount collected. They've added landlord agency to the list of agency types. They've strengthened the indemnity language. And they've added authorization for manager to use automatic and AI generated messaging. That's going to come up more and more. And there's more information about that I'll show you in a later slide. In the purchase, and if you are a property manager, I highly suggest you pull out those forms and go through those changes. Read the entire form since it has been entirely reformatted. Purchase and sale agreements, again, a lot of these changes, notice was capitalized. Warranty, we've already talked about that, where they added that right to extend closing date. We've talked about that. We've talked about a lot of these issues. So really, one of the great things for 2026 is there's not a ton of changes in the purchase and sale agreements, really, or in the financing exhibits. Warranty, right to extend closing, holder of the earnest money, again, that they're working with or representing one of the parties. Agency disclosure, disclaimer, entire agreement, clean condition. All of those changes I've covered at the beginning of the class. New construction, purchase and sale, again, a lot of the same verbiage. One of the things they did add in the new construction purchase and sale, now a lot of builders are using their own purchase and sale agreement, or a purchase and sale agreement copyrighted and authored by the Atlanta Builders Association. But there are some builders that do use the GAR new construction purchase and sale. So for those situations, again, if the buyer defaults, this is under the default section, remedies for the seller. They have added that the seller's sole remedy shall be, it did say to retain the earnest money. They've added all construction deposits. Now, that issue had already been addressed earlier, that typically construction deposits are non-refundable unless the seller defaults, but they've just added that into the actual default paragraph under remedy for the seller. Counter offer. Oh, I'm moving pretty quickly, actually. Counter offer and agreement to reinstate. Counter offer to or modification of. So basically, this is an issue with counter offers that continually gets confused by actually a lot of agents as well as our public. When you go binding with a counter offer and there were exhibits that were included in the original offer, You do not need to go back and initial those exhibits. That has always been the case. The verbiage in the counteroffer says it includes everything in the original offer, including referenced exhibits, except for what's changed. But GAR's still trying to make this clear. So they've added this at the end of this paragraph. Effects of accepting this counteroffer creates a legally binding agreement between the parties, even though other parts of the agreement, including exhibits, have not been signed or initialed. For some reason, people didn't believe brokers or the verbiage. So they've just tried to clarify that even more. Yes, a lender will typically require signatures on those forms. So what do? You're either going to do you're probably going to do a clean copy. So because that is true. That's one of the issues is the lenders will typically require initials on those forms because I guess they don't. Well, I'm not going to be snarky. If that's the case, I suggest you do a clean copy. And in the clean copy paragraph, they've added that basically it says.
This up real quick.
Hang on 1 second. Basically, this has always been the case at any time prior to closing, if either party, if so requested, the other shall sign a conformed or clean copy of the agreement, combining the terms of the original offer with the controlling and supplemental provisions of this counter offer into one document, including initialing or signing, as the case may be, all exhibit. And I've taught this for years. I'm glad GAR has put this in there. Include special stipulation 622, conformed copy of agreement in conformed clean condition. Basically, that says if there's any typos or anything inconsistent in the clean copy from the original copy, the terms of the clean copy shall control. That's what that special stip says. But what GAR's adding for 2026 is all dates referenced in this conformed or clean copy shall be the dates reflected in the binding agreement rather than the date the conformed or clean copy is signed. So apparently that has been confusion. I do a clean copy a few days later. What date do I put on the clean copy? So that is clarifying that all dates reference basically it's just a cleanup of the original of the terms that the parties under which they went binding. All right, pre-showing compensation agreement section. They've just changed the there we go, language clarify. They've just changed the date section. Again, they've done this throughout all of the forms. It used to say this blank day of blank 20 blank for property located, and now it's just one line. This day of, I need to move these slides up a little bit. It's just one line. It says this day of fill in the blank. So you would, however you write it out, December 9th, 2025 or 12/9/25 or however you choose to do dates. It's just one line, fill in the blank. Love, love, love this change. On the agreement to reinstate the contract. So this is a situation, buyer and seller were under contract and it did not close. For whatever reason, it got terminated or expired. A lot of times what happens is let's say, for example, a buyer is under financing contingency, and for whatever reason, there's some issues with the lender, and they're not getting the approval yet, and they don't want to lose their earnest money, so they can get a denial, but something happens. Or let me give you a better example. A better example is buyer and seller are binding, and lender sends out an appraiser. Property appraises for way lower than the purchase price. The buyer goes ahead and complies with the financing contingency exhibit and sends an amendment to the seller, asking the seller to sell them the house for that low appraisal price. Seller says, no, I'm not going to sell it to that. In the meantime, the buyer has also requested that the appraiser reevaluate the appraisal, that for whatever reason they didn't look at comps properly, whatever. So they're trying to get the appraisal value up, but they're about to run out of time to terminate the contract and lose their earnest money. So the buyer sent the amendment to the seller. The timeframes have gone by. Seller's not going to sell it. The buyer terminates under the appraisal contingency. They would be entitled to their earnest money back. But in the meantime, they've asked for an appraisal review. It hasn't come back yet, but a buyer doesn't want to lose their earnest money in case it doesn't work out. So you would terminate the contract, but you don't disperse earnest money yet. You just wait a little bit because everybody knows what's going on. Lo and behold, we get the appraisal value up, and it's an amount where the buyer's willing to buy and the seller's willing to sell, and you need to reinstate the contract. That would be a great use of the reinstatement of the contract. So that's sort of that scenario. What GAR has added, so one party is going to initiate this reinstatement. What GAR has added for 2026 is this offer to reinstate the agreement set forth shall expire at blank o'clock on a certain date. Because let's say a buyer does this, but in the meantime, in my example, in the meantime, a buyer finds another house they want to buy. And they're like, well, we've already done everything. We've inspected this one. We paid for appraisals, blah, blah, blah. We'll do this, but I'm not going to hang on and wait for forever for the seller to respond. So I'm going to offer to reinstate the contract, but only until a certain time frame. So anyway, it just keeps it from being open-ended also, because the other situation is one of the parties initiates an agreement to reinstate the contract, never hear from the other party, never hear from the other party. Seller goes and sells to someone else, or buyer goes and buys a property. All of a sudden you get this back signed, reinstated. You're like, uh-oh, rut-row, Relmo. What do we do? So I love that GAR put in this basically time limit on this reinstatement. Yes, Beth, that is a great, there's another situation where during the due diligence period, the seller is not responding in a timely fashion. So the buyer wants to terminate to protect their earnest money. But once you hear back from the seller, they're like, no, I really want this house. Obviously, I made an offer on it, went binding, and you would reinstate. So again, just love that they put in a time limit to avoid issues in the future. Again, so that it is not open-ended in case the party initiating reinstatement changes their mind. All right. There is a lot of changes to the seller's property disclosure statement, and it is 11 o'clock. So I think now would be a good time to take a break. So everybody, let's take a 15-minute break. It is 11 o'clock. Come back at 11:15. When you come back, type in your name, license number, email address, and phone number, and I will see everybody back at 11:15. All right, welcome back. So we are going to continue on with more changes that the Georgia Association of Realtors has made to the 2026 contract package. So let me share my screen again. And get the slideshow started again. From slide. There we go. All right. Again, I still have a lot of changes to cover, so I'm going to go pretty quickly, but We will get it done. So, sellers' property disclosures, it seems like they've changed a lot. They've just added a lot. We've already talked about instructions to buyers and sellers. They've added a lot regarding water, and that's in all of the disclosures where it addresses these lists. So, under the part about subject to a lease, they've added propane and fuel tanks that potentially are leased. They've added septic system hasn't been approved. They added health department because in some counties it is the health department that makes the approval, not a government authority. I guess you could consider the health department a government agency, but again, what is it that Bobby said? When in doubt, spell it out. So I think GAR is going by that as well. Now, here's what they've added in all of the property disclosure statements where they're talking about water. They left in the word flooding. They took out draining moisture and springs and added just generic water intrusion. And they've changed a lot of this section having to do with water, excluding water intrusion caused by plumbing. Has there been any water intrusion? They took out the specific places, just generic water intrusion or physical damage to the property and or its improvements and or contents caused by water from the exterior of the improvements, quote, flood. Has there been any insurance claim covered under the National Flood Insurance Program or private flood insurance policy? Have there been any repairs to the property or improvements located on such property as a result of flood, regardless if there was an insurance claim filed or not? Have you received any notification regarding the designation of the property as a repetitive loss property or severe repetitive loss property? Have there been any material erosion? Is there material erosion affecting the property? Seller received notification to obtain or maintain flood insurance under federal law because of form of disaster assistance received by any owner of the property. Is flood insurance required by current mortgagee? Does any part of the property fall within the 100-year or 500-year floodplain as designated by FEMA? Are there any retention ponds, detention ponds, or similar facilities, streams, springs, so forth, only visible during certain times of the year? So again, that water section has been completely redone. In the short property disclosure form, that's just the sellers. How far back do these flood issues need to be? I'm working on a deal flooded in 2009. I don't have a specific answer for you, Peggy, other than when in doubt, spell it out. I think public sellers are better protected when they disclose what they know, especially if they have knowledge of it. And you, as a licensee, you have disclosure laws by license laws that are incumbent upon you with specific knowledge. So if you know, I would disclose. It's better to let a buyer have all the information and make an informed, educated decision rather than something potentially being an issue, even if, let's say, there was no legal requirement to disclose it. It may cost you and or your seller money to defend their position. So I would current ownership or knowledge. You guys, you're asking me legal questions. I'm not an attorney. Again, I think whatever information you have specific knowledge of, I check with an attorney, but I generally think it's best to disclose what you know. You as an agent, your license there are license laws. And if you're a realtor, there is the Realtor Code of Ethics too. So you need to look at those documents for disclosure of those kinds of issues. But moving along, under the shorter form, the seller's disclosure of latent defects, they've added caveat emptor or buyer beware is the law of Georgia, and the disclosure may not be modified by the buyer. So I don't know why. Obviously, I know why they added caveat emptor, but I think that's interesting that they had to add that it may not be modified by the buyer. I'm curious what prompted that. Okay, lead-based paint. This is another huge change. This is probably the second after the due diligence change. This is the second biggest change that is going to impact more agents on a regular basis than any of these other forms. This change is based on a new regulation by the EPA. Note to you brokers, you may want to consider a policy for all buyers and sellers agents to initial the lead-based paint disclosure on all contracts where the exhibit is included. You'll see why in just a second. So, this is the lead-based paint exhibit. In the agent's acknowledgement, they have a place for the seller's agent's initials and the buyer's agent's initials. And they just reference the federal law that the seller agent has informed the seller of their obligations under federal law and is aware of his responsibility to ensure compliance. Now, what the biggest difference is, there was a place last year, it was maybe 2 years ago, but definitely last year, where the buyer's agent had to initial the lead-based paint disclosure only if the buyer's broker was getting compensated directly from the seller. Now, based on this federal law, there is a change. Buyer's agents need to initial this lead-based paint exhibit if they are getting compensated any way whatsoever from the seller side, either directly by the seller or indirectly through a co-op brokerage agreement. So if buyer's broker is getting compensated by the seller directly or by the seller's broker in a co-op, buyer's agent needs to initial. Again, brokers, you guys need to think of a policy. I think it's probably good practice. If there's a lead-based paint exhibit included in the contract, both agents need to sign this. And what you're signing is acknowledging that you've informed the seller of their obligations to disclose information about lead-based paint to the buyer. It's weird for a buyer's agent to have to inform a seller, but again, this is EPA and federal law. This is not a new form. This is a reminder of a form that came out last year. Buyer's brokers notice to seller of seller's obligations regarding lead-based paint. I have included this in this slideshow because you need to initial this. Well, what you're initialing is saying you've informed the seller. Buyer's agent has informed the seller of the seller's obligations. Well, don't sign it if you haven't done it. You need to prove you did it. Well, how do you do that? You need to initial this form, and this is how you, as a buyer's agent, inform the seller of their obligations per EPA. You use this form and you send it to the listing agent. Buyer's brokers notice to seller of their obligations. And this is all you have to do. You sign it, you send it to the listing agent. Again, this is not a new form, but this is what you need to send when you're signing that other form. Why doesn't GAR just make the lead-based paint mandatory to be signed with every contract? Makes it easier. It could make it easier, and that could be a broker policy, but you don't have to disclose the basis of lead-based paint if the house or nothing in the house was painted after 1978 because there was no more lead in the paint. So, during the foreclosure years, a lot of foreclosure banks did that, but that's going to be a broker policy or an agent point of practice. But sometimes it's superfluous and you might be bringing up an issue that isn't an issue. And if you bring it up, there's a separate 10-day opportunity for the buyer to inspect. So, yep, absolutely. Antique typically means it was built or painted prior to 1978. So the lead-based paint exhibit says if the house was built prior to 78 or there is a potential lead-based paint hazard which include, just like Jim's pointing out, things like an antique mantelpiece, reclaimed barnwood, things like that. Okay. Woo, our favorite community association disclosure. Again, basically, seller's responsibility to disclose fees that a buyer is going to incur buying a property within this association. A lot of times, you guys, it is only the seller that can determine these, that can get this information from their HOA or management company. Not designed as a punishment, but because the sellers are the only ones that can get this information, if the seller does not accurately disclose the fees, the seller pays at closing. This is just more and more and more highlighted this year. So again, that's spelled incorrectly up there. Seller's directions for completing this community association disclosure. Seller is encouraged to contact the community association management company, property manager, and or association board, as the disclosure must be filled out accurately and completely. Seller acknowledges that information regarding community associations can be difficult for buyers to obtain, and buyer is relying on this information in the disclosure when deciding whether to purchase the property. If new information is learned by the seller which materially changes the answers herein, seller must immediately update and provide. You guys, this is important. This has been in here, but this is going to come back in a second. So the seller has to fill this out and include it in any offer, counteroffer, binding contract. If the seller learns of new information, the seller must immediately update and provide buyer with a revised copy of this disclosure up until closing. Notwithstanding the seller's duties to update the disclosure, any payment obligations incurred by the seller pursuant to the disclosure due to the under disclosure of any amount herein will be calculated based on the amount stated on the initial disclosure and not on the amount subsequently provided on any updated disclosure, excluding payment obligations related to disclosure of special assessments that come under consideration after the binding agreement date. So, seller must still update the disclosure if new information is learned prior to closing, and the seller must pay the difference between the fees for the buyer that were disclosed and the actual fees. But in 2026, this difference that the seller has to pay is based on the amount the seller initially disclosed and not the updates. Then they've changed community to condominium, association, homeowners. They've just added some stuff in there. Some of this stuff is just, again, more explanatory. Community association defined is every type of voluntary or mandatory membership community association, including but not limited to condo, property owners, homeowners, master, so forth and so on. They changed that word defined to purpose. Disclosures and acknowledgement regarding fees. Owners of real property in communities where there is a mandatory membership community association are obligated to pay certain recurring fees, charges, expenses, and assessments to the association. Fees can and do increase over time. On occasion, there may be a need for a special assessment, which is a fee levied on owners to fund specific community association improvements or projects. Except as otherwise specifically stated herein, buyer assumes risk of and shall pay any fees that increase or come under consideration after closing. So a buyer, it seems obvious to us, but it's not necessarily to buyers. Buyers, you can't come back on the brokers, agents, or seller for fees that come up after you are now the owner. Seems obvious, but annual, regular association dues. And again, they've just changed this just a little bit. Mandatory fees, master association fees. If applicable, buyer will be required to pay a mandatory fee for blank. There are some generic fees that have to be paid that isn't necessarily specifically accounted for in this form. This fee does not include special assessments, transfer, initiation, or admin fees, utility expenses billed based on usage, move in, move out fees. That would be something else that might be specific to a particular association. And again, they've just changed this verbiage a little bit. They haven't gotten rid of this. They've just rearranged where they put it. They did add buyer shall pay any accurately disclosed prepaid fees. And again, they've just moved this marked out section to a different section. Special assessments, they've just capitalized that. And they've added for any special assessments, adopted special assessments. They've put that. So ones that are not, they put ones that are actually have been adopted by the HOA. So a question is, it should become standard practice to verify immediately prior to closing for any special assessments. Yes, I think that would be a good idea. And a lot of times a closing attorney, when they get those HOA letters, a lot of that information would be included from the HOA. Special assessments arising after binding agreement date and prior to closing. Special assessments that come under consideration prior to closing. Again, a lot of this is just clarified a little bit, but they did add prior to closing and are disclosed by the seller to the buyer within 7 business days of the date of the notice of any meeting at which a special assessment will be voted on. Agents, when you guys are working with a seller in any HOA, but especially a condo or any of them, you need to tell your sellers, hey, y'all need to pay attention when your HOA meetings are, because if there is a meeting that occurs between, or actually before, when they go on the market, but especially between, actually anytime between when they go on the market and closing, your sellers need to know what happened at that meeting, especially with respect to money. And then it goes on, notwithstanding the above, buyer's portion of any special assessment that came under consideration. This is the same verbiage that was there that just got moved to a different section and spelled out a little more, just more and more. So buyers understand what they're getting and potential fees moving into a community that has an association. And again, special assessments that arise after closing, that is a buyer's responsibility. Seller warrants that the seller has accurately and fully disclosed all special assessments passed or under consideration to buyer and will timely notify buyer as set forth above if a special assessment comes under consideration after the binding agreement date and prior to closing. This warranty and all payment obligations in Section 4 shall survive closing. That's very important right there. So again, they've added some dates and I'm sorry, I did not read this section. Let me go back and read this section because there are termination rights for the buyer, notwithstanding the above. Buyer's portion of any, again, we're under the special assessments section. Any special assessments basically that come under consideration between the binding agreement date and closing. If that special assessment ends up being more than the actual annual dues, the buyer has termination rights within 5 days of being notified of that, and they will get their earnest money back. So that is key. I should have read that more thoroughly out loud. All right, transfer initiation and admin fees. Again, they've just rearranged this stuff, so they're referencing the sections that has been in. And other association expenses, they've just more clearly spelled out the closing letter. The seller is required to pay cost of any association account statement or clearance letter, including all amounts required by association or management company to be prepaid, so forth and so on, within 2 days of notice from the closing attorney, because the closing attorney gets the closing letter. Seller shall pay for the closing letter as instructed by the closing attorney. Seller's failure to follow the instructions of the closing attorney may cause a delay in closing and additional fees being charged to the seller. The closing letter fees are not transfer initiation, so forth and so on. And then they've added a section about move-in and move-out fees. All right. Changes to seller discloses change. Would they still be responsible for the increase in fees? Yes, if the seller discloses the fees properly, but the HOA makes changes during the transaction, the seller discloses the changes, they are responsible for the increase in fees. That is verbiage in the new 2026. Okay, 2 new forms. Unsafe property disclosure and hold harmless agreement and buying property sight unseen. Consider using this unsafe disclosure, especially when working with investors or showing fixer-uppers. And always, if a seller's agent has informed you of any hazardous conditions. This is the new form, and you just this is if you, it's really weird because you're working with a buyer, because it's signed by the buyer's agent, buyer's broker, and the buyer. You might not know of any issues disclosed to you by the seller, but if there are, you need to list those out there. And then it goes on that basically they're not intended to be an exhaustive list. As an FYI, this is very similar to 2 forms that were new in 2025. The visitor's sign-in sheet that was really designed for open houses, but a lot of sellers were using them for showings and viewing a house under contract. Very similar, but these are for the buyer and the buyer's agent to sign. Again, just bringing these to your attention that were new in 2025. Sight unseen. If you are working with a buyer buying a sight unseen, please, 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 please use this brand new form. It says, buyer, dude, you're buying it without seeing it. There's lots of things that can be different in person than what you are perceiving on any video or pictures or descriptions. And it says, buyer, nevertheless, you are choosing to move forward with buying the property sight unseen, and you waive and release the undersigned buyer's broker and brokerage firm if it doesn't meet your expectations. Financing contingencies, we've already addressed the majority of these changes. In the no financing contingency exhibit, where a buyer is getting a loan, they're just not making the deal contingent upon that, or they're actually using cash. They've that's this form, and they've just put all cash, and then they did add that whole paragraph about the master insurance policy that's in the financing contingency exhibits. They've added that paragraph to the no financing contingency exhibit. And a similar change that they did last year, amendment to, it used to say sale price. It's now amendment to purchase price. That was a mid-year change. So they've made that change. Closing attorney acting as holder of earnest money. Basically, they're just clarifying that if an individual attorney, if you put a person's name, it's who works for that law firm, is named as the closing attorney, it's anybody in that law firm. So again, sort of obvious, but nothing's an issue till it's an issue, and we're going to avoid them up front. Brand new form, brokers. You guys are going to love, love, love this form. This is my favorite form as a broker. Holders notice. So if there is a situation, you may have to use this twice. Basically, the holder, if they don't get the earnest money or it's not honored by the bank in the contract, the holder has to give notice to the parties that, you guys, the contract is a receipt for that money. If it says ABC Broker is holding thousands of dollars in earnest money, that's a receipt. I've got that money. If I don't have that money on deposit, I need to say, hey, this is a fake receipt. I do not have that money. There's been all sorts of issues throughout the years with agents knowing that the buyer didn't send in the earnest money or whatever. An agent can't send notice. Agents, you guys aren't the holder. So some holders were doing it by email, some holders weren't doing it at all, so forth and so on. So GAR has created this form to make sure that all the parties know the buyer's in default by because earnest money is not on deposit and if they've cured it. So here's what this form looks like. You fill in the date, the parties, the address. Holder hereby gives notice to the buyer and the seller. Buyer has failed to deliver earnest money. Buyer has the right to cure this default within 3 banking days. Or buyer's earnest money has been returned to the holder and dishonored by the financial institution upon which it was drawn. Buyer has the right to cure this within 3 days. Now, brokers, and if I have any closing attorneys on here and you two are the holder, you would use this form as well. The buyer, if they cure the default, you're good. Should send notice. But if not, this form is important because a seller has termination rights and you do not want to you don't want to deny that seller of their termination rights. So the first time you would use it is when the earnest money is not on deposit. The second time potentially is if the buyer never makes good on the money. The buyer has not cured the default and you would send it again. Again, I love this form as a broker, as a holder of earnest money. Okay, let me go back. Comment in the chat. Unsafe disclosure form. Represent a buyer. Seller just moved out, but will only provide latent defects disclosure and check no to everything. Of course, the buyer loves the house. Can I do that form without listing any specific items? Yes, that's a great question, Peggy. This form, let me go back because this is a new form. You could put something to the effect of no specific known, but this next sentence says this is not an exhaustive list where these items identified above are not intended to be an exhaustive list. So this is really a good form to use because it does have that hold harmless language in here. So you could put something like no specifically known items, but there are potential hazards on the property or something like that. So, yep, great question. Closing attorney, always get the earnest money proof of deposit, certified checks or money order. Okay. Or wires. But nevertheless, sometimes we don't get those. So, all right. Sale or lease contingency exhibit. A few kind of minor changes to this, kind of a little bit interesting. Under this section, in the event the contingency period. Okay, so this is in the first section, and basically you guys know buyer says, I'm buying your house, seller, but it is contingent upon me selling my current home. There's a fill in the blank where you can put in a date or a checkbox that says that you're giving me until the closing of this contract to close on my current home. So you would do a back-to-back closing. That time frame is called the contingency period. This says in the event the contingency period ends without the contingencies being fulfilled, in other words, I don't sell my current home or lease it, the agreement shall automatically terminate at that time and buyer shall be entitled to the earnest money without penalty. That had always been the case, but it got spelled out. It just simplified the language. And they've added this section only applies if there's an existing contract, that the buyer shall have the right but not the obligation to promptly terminate the agreement upon delivering notice in case the buyer shall be entitled to the right of the earnest money back. Okay. The one quick thing that GAR pointed out in the class, they changed will have to shall. There was apparently a Georgia Supreme Court ruling where shall is legally interpreted as a command versus will as just grammatically is something that happens, not grammatically, but definitionally something that happens in the future. But apparently shall is a command, so they've changed that to shall. You'll see those changes actually throughout the contract. Now, this part's a little interesting. This is in the kickout section. This is if it is subject to a kick-out, there's a potential for additional earnest money if the parties agree on that. They've added this sentence prior to seller giving buyer notice that seller is exercising the kick-out clause. The contingency or contingencies referenced above, meaning sale or lease of buyer's current property, may be waived by the buyer upon notice to the seller and shall no longer be part of this agreement. And then in the section about what contingencies potentially get removed, they took out this sale or lease of buyer's property contingency, no longer be part of this agreement, because they've added it up there. All right. Again, this is still in the sale or lease contingency exhibit. In the section about the kickout, they have in here seller can still request proof of funds. They've changed it to proof of evidence of ability to close, if it's no longer subject to a financing contingency. All right. Oops. Okay. Another form they've made, they just added possession. This is the amendment to remove the inspection contingency. Don't get confused, you guys. This has nothing to do. No, Bitcoin is not addressed in GAR, but AI is, but not Bitcoin. This is not to be confused. If a contract's subject to due diligence, this is not an amendment you're going to use. But if you do make a contract subject to an inspection, like they did years and years and years and years ago, like 25 years ago, they've just added a possession. I'm not going to belabor that point. I still have a bunch to cover. So, and we've got 40 minutes. So, is that right? Yeah. Owner's property disclosure on a lease. Again, if you have a landlord and they fill out a property disclosure statement, they've just made it more specific. It's very similar to the seller's property disclosure statement when they're selling a house. It's just specific to a lease. They changed the word buyer to tenant, seller to owner, and all these other changes about all the water and all that. That's all the same. Okay, residential lease for any of you guys that deal in leasing, or even if your company does not allow you to do property management, many companies do allow their associate brokers, their affiliated licensees to help sellers put a house up for rent and help a buyer or a tenant sign a lease. So that's tenant procurement, and tenant placement is not property management. So in the actual lease, I'm not going to spend a lot of time explaining this. If you do leasing, you'll want to look at all these changes, but let me just address what they are. They have added a fee for a landlord having to pay a tenant's utility bills. They are, I should have put in here what is being deleted, but they deleted something. I have a feeling they just rearranged it. Utility connection charge in order for landlord or manager to perform an accurate move out condition report if the utilities had been turned off. There could be an additional disconnect fee for that. So they've just addressed those issues. Again, utility charges in the security deposit. If tenant fails to transfer all utilities, tenant's name immediately after commencement of the lease. You guys, a lot of this has to do with in some counties, not all counties, but in some counties, even if a tenant moves out, the issue is the tenant will want to take the utilities out of their name, or the landlord, if it's well, bottom line is a lot of water companies will not turn off the utilities, or specifically water, especially DeKalb County, and they'll keep it on. And let's say there's a vacant property and the landlord has to turn on the water in their name. They'll have it on. When a tenant comes in, the tenant's supposed to put it in their name, but they never do it. and the water's still on. So the landlord ends up paying for water the entire time, and it just gets crazy. So that's what a lot of these changes are with respect to the utility connection charges is, okay, tenant, you're not gonna, you can't rent a property for me for a year and have me pay your water bill if that wasn't part of the lease. Administrative fees, they put prior to commencement of the date of occupancy, but they had some paying at the end. So they've just add can be paid. They took that out. So admin fees can be paid anytime. This is interesting in holding over. They've changed it. It used to just say holding over rate. They've added the term rent. Again, you guys, words have meaning and legal connotations in Georgia. They put holding over rent and additional rent because if it is rent that is not paid, a landlord may evict. If it is just a fee, it is not evictable. Evictable. I just made up that word. So that's why they changed it to rent. Again, in the lease, if you are working with any landlords that are leasing properties built prior to 78 or have a potential lead-based paint hazard in the house, they too, you guys, you need to do these lead-based paint disclosures and brochures because you should do them with the EPA. And they just corrected, there was an incorrect website reference, and they just corrected the website. They've just added more specific things regarding a lease, including hot tubs, treehouse, swing set, bouncy house, zip line. You can't keep chickens, goats, sheep, rabbits, or any other animals not listed on the pet exhibit. And you can't have any, like, you can't go buy a portable fire pit and light a fire, think it's out, and it smolders and move it under the house and catch the house on fire, or storage buildings. That's what those issues are there. Here we go. This, I imagine, is going to be addressed in many more of the GAR forms moving in the future. I'm not going to read it all to you, but basically it says, okay, tenant, once you become a tenant, the landlord or property manager may communicate with you automatically via automated or AI-driven communication. It is a disclosure about that. And again, looking at my crystal ball into the future, I have a feeling this is going to be addressed in many more of the GAR forms moving forward. Okay, independent contractor agreement. Now, I know you guys, if you are already an affiliated licensee with a broker, you've already signed one. Brokers, I know a lot of you guys have your own independent contractor agreement. Nevertheless, there are a couple of things I want to point out because there is some great changes. There are some great changes that GAR made to this that I think brokers, y'all might want to add or address in your own independent contractor agreements. One is when you bring on a licensee, what types of real estate transactions are you allowing your licensee to do? Residential, commercial, land, lot, lease, residential leasing, commercial leasing, property management, commercial property management. Those all involve different skills, experience levels, so forth and so on. And this might be something to take a look at in your own independent contractor agreements you have. And this just says licensees cannot perform any of the activities that weren't checked in this prior section. And again, they just changed member of the following multiple listing services. It used to be the broker belonged to the MLS and all agents by virtue of being with that brokerage belonged. There are some MLSs like Georgia MLS, for example, a broker can belong, but not every agent is required to belong. So that's a different issue. And this is regarding having automobile coverage, proper car insurance. And I love this because a lot of brokers do this, but not all. It says a different information attached here to and incorporated herein, broker's office policy and or procedures manual. And does it have something else here? No. Oh yeah, there is a little bit more. So hang on, I'll get to it in a minute. Lead based. Here's the thing about lead based paint. So they've added it in there. Again, I think it'd be a great policy. Some of this stuff is just not wonderful. This is what I really like. Rental property agent changed to licensee, settlement serve. They changed some of that stuff. But this brokers, you guys, this is something that I think you might want to really take a look at. They've added a whole sentence about office policy and procedures manual. The manual of the broker is hereby incorporated herein by reference, and licensees shall comply with the same. In the event of a conflict between the independent contractor agreement and the manual, this manual or independent contractor agreement shall control. That's really important because some of you guys have agents with you that have been with you for years and years and years, and you'll change a policy in your policy manual. Well, is your agent required? Are those changes still enforceable on them or not? And just to make it clear to everybody, this is something that I think would be a great addition if you don't already have it. We already have it at maximum one. But if you don't already have it, something to absolutely consider as a broker. All right, couple new things. I'm going to go quickly because I want to get to some of the changes that were covered mid-year last year that are still in play. Exclusive commercial tenant buyer brokerage engagement. This is a new form because for commercial, a lot of times you'll have a tenant that's renting a commercial property, and over time they end up deciding to buy that commercial property. Well, they're already in place, so you want to basically, this form is for those situations. It has not yet been set up with the fill in the blanks in paragraph A and the corresponding paragraphs in B. That change will probably occur either mid-year or next year. But again, I'm not going to go over this, but it is exclusive commercial tenant/buyer brokerage engagement agreement. In the commercial purchase and sale agreement, again, a lot of these issues we have already covered earlier. And they've added this. This is already in the residential purchase and sale agreement, that if a holder ends up dispersing a buyer's earnest money to the seller as liquidated damages, the holder may require the seller to complete a W-9 if it's more than 600, which means they're going to send them a 1099 at the end of the year. Again, commercial, there is a brand new form that is a new due diligence list that it says commercial, it's commercial, but it's for land. So that is all specific things. The 2026 forms will be available to all agents after January 1st, 2020. What did I do? Cancel. I don't know what I just said. After January 1st, 2026. But I'm going to put in the chat one more time the handout. So in the handout, you do have a list of all of the changes, that index of all the changes, but you have access to the forms after January. And there is I talked about that. A new exhibit, or they've added to this exhibit. Again, this is commercial, seller warranties and representations. They've added anti-terrorism, cemeteries, endangered species, foreclosures, historic structures, insurance, possession, status of seller, utilities. Change seller to owner in the exclusive commercial lease listing because they're not selling it. And a special steps. This is the one they have. Some of these other ones, they've just changed, again, commission to compensation. They eliminated no commission owed by the buyer, and they've added a new walkthrough. So this is what they got rid of. No commission owed by the buyer. And this is what they've added. If the property is in a jurisdiction that does not issue certificates of occupancy, buyer may only refuse to close if the cost to complete the items on the walkthrough list are reasonably estimated by the seller to cost that should be more than $5,000 to complete, and the house is otherwise substantially complete. Again, in Metro Georgia, I am not aware of any counties that any of my agents deal with where you do not where you can close on a property without a certificate of occupancy, but apparently throughout Georgia there are. And again, there was a special stipulation about subject to the master insurance policy. That is all changed to the verbiage we've already read. So it is a special stipulation, the same one that is in all of the financing forms. Okay. Bonus tip. This is not new, but we are seeing, for whatever reason, many conventional lenders, a lender where a buyer's getting a conventional loan requiring repairs. It is not addressed. How do you address it? So there is this same verbiage. This is the exact same verbiage that is in the GAR, FHA, and VA financing exhibits about if there are repairs mandated by the lender, who pays for them as long as they're not more than X amount of dollars. If they are, how do you deal with that? Again, this is lifted from the VA and FHA exhibits. Just bringing to your attention, it is a special stip that even if you're getting a buyer getting a conventional loan, you might want to address, because for whatever reason, we are again seeing a lot of repairs required. I've got 25 minutes to cover the mid-year changes. So some of these are important. If you've been doing business since June, some of these you are aware of, some of them you might not be aware of. If you have not been doing business since June, and the last contracts class you took was in January or last December, you need to be aware of this. So hang in there. Let me cover these changes, and then we will be done. Again, there is a list of the 2025 GAR mid-year changes. If you want to see those, you need to get those before January. This index goes away from where you can access your forms 12/31/25. So if you want to pull this down, go ahead and grab it now. Delayed marketing, again, I'm not covering that because they changed it. They put it in a different place in the brokerage agreement. Limit on brokers' liability. Basically, they just it was one big old long paragraph. They separated it out and basically just said, okay, broker, and it also means agent, you have no liability for information that later turns out to be incorrect, and your protection extends after termination of this agreement. Hold harmless, again, for inaccurate information. Earnest money handled by anyone other than the broker. Injury, buyer's negligence, so forth and so on. Again, this is all information that is protection of you, and just slightly modified, and again, survives agreement. They change. This is a change I love, you guys. If you didn't pay attention to this, this is wonderful. Where it said closing costs, it used to say closing costs. It now is what it really is: seller's monetary contribution towards a buyer's cost at closing. Because sometimes that money that a seller is giving as a buyer credit isn't used towards what's labeled as a lender closing cost. It's just a buyer credit. It's a seller's monetary contribution. In the warranty, it says any title objections raised by buyer prior to closing that seller was able to satisfy, that is waived. Again, some of this is legalese stuff. Good, seller has to convey good and marketable title. Again, this is just saying that a seller is required. Oops, I do that. A seller is required to pay whatever fees they have to pay to convey good and marketable title, and for payoffs and estoppel letters and so forth and so on. This whole compensation of the brokers paragraph is just reworded and shortened. This is the new one in June of 2025. This was the original one in January of 2025. It basically says brokers have performed good and valuable service, and you have agreed to pay them, to compensate them for that. This I love. This again was, an addition in June of 2025. You buyer's agents, you need to understand that if earnest money is addressed in the creation of a contract, if it's part of a binding agreement date, regardless of where it is, in actuality, if the buyer never sent it, if they sent it and the bank didn't honor it, it is still part of the contract. And unless the seller has otherwise waived seller's rights to terminate due to the buyer's failure to pay earnest money, seller may, after the termination of this agreement, sue the buyer for any portion of the earnest money that was either not paid or returned for insufficient funds, or the payment was stopped. Buyers must understand that earnest money is part of a contract, even if they haven't sent it. Even if they haven't sent it to the holder, or they stopped payment, or never had the funds. Buyer's contractual responsibility, they still have a liability. We have some buyers that think, oh, I just won't send it. If I terminate and default on the contract, no harm, no foul. Yeah, harm, foul. You are still liable for that money. So GAR added that in June, and I love that they did that. Oh, this is just a change in June that basically the brokers involved in this transaction are third-party beneficiaries, and payments to them are spelled out in the brokerage agreements or described in the customer agreements, but brokerage agreements are not required to be attached. Delays caused by emergencies, that got added in at the beginning of the year because of all the horrible weather issues that we had. And basically it said delays caused by emergencies. In other words, there's no power, there's no electricity, there's no internet. How on earth can anybody sign anything? So it did some extensions for that, but it said not more they've changed it that not more than 8 days, and it doesn't have to be extended if there is an emergency. And it's just an emergency if the governor declares that county a state of emergency. That's when all of this stuff kicks in. Entire agreement modification. Again, I've addressed this earlier that they're trying to get everything in the contract. It does make an exception for the pre-showing compensation agreement or other separate agreement of payment of broker's compensation that is not part of or amended. Obviously, the pre-showing, you don't have a contract yet, and any other thing regarding broker's compensation that isn't attached as part of the contract. Does the contract cover recent GSCCA outage? No, and that's all fixed now. So there should be no, so that's not a county governor declared a state of emergency. And that has been corrected now. Actually, Peggy, the GSCCA is back online. All right. Again, this has been in here, rules for interpreting this agreement. They just added handwritten changes and buyer and seller acknowledge and agree that agreement to seek amendment to purchase. Okay, so basically what they added is if a buyer's getting a conventional loan and the appraisal comes in low, the buyer is required to give the seller the opportunity to sell it for the lower appraised value. That's been the case for several years. In January of this year, they added that in an FHA or VA loan, the amendatory clause, which is the appraisal contingency, if it comes in low, the buyer still has termination rights through day of closing. Buyer, if the appraisal comes in low and the seller does not agree to sell it to them for that lower price, the buyer can still terminate through day of closing and get their earnest money back. But what they added is, in an FHA or VA insured loan, the buyer now is required to give the seller the opportunity to sell it to them for the lower appraised price. And I already passed that. What have I done? Okay, hold on. I'm going too fast. Oh, here we go. And that is in there. And what this is saying is it still does not conflict with the amendatory clause. So that's what they added in 2026. In June of 2025. I'm getting my dates a little mixed up. In the buyer's broker's compensation exhibit, they just switched the order, changed agreement to exhibit. Some of these changes really aren't that information. They've already changed the instructions. Oh no, this is a community association. Just click. Yeah, they've changed that. So I'm not going to cover that too much in depth. Again, they've radically addressed the community association disclosure. So I'm skipping over that. This is not new. Again, just a reminder. If you're working with a buyer who's buying a condo, just because a condo complex or townhouse complex was approved for FHA or VA loans in the past does not mean it's approved now. If I highly suggest, as a point of practice, if you're working with a buyer buying a condo or townhouse and they're getting an FHA or VA insured loan, that you use these two special stipulations. Great ones to use to protect your buyer. And again, this was added in January, revised in June, and now it is part of all your financing exhibits. Oh, I made it. All right. So, well, as a ruse, I talked very quickly. So a couple things before you go. Number one, confirm all your contract questions with your broker. Please attend our additional courses, and you can get them through our school website, Real Estate Academy of America, or max1calendar.com. That is the school. Again, the handouts are available, and we have handouts for tons and tons of our classes. We have such a high value on training and education that a lot of our handouts are free. There are videos of all of these classes. You are more than welcome to watching the videos. You won't get CE credit automatically for just watching a video, but feel free to download any of the handouts. Credits will be recorded within 3 to 5 business days. This specific class does count for broker and CE credit. Again, some of you know, and I appreciate your subscribing or watching the channel. I have a YouTube channel, Real Estate Made Crystal Clear, that is designed for all agents in Georgia. And I cover contracts, license law, all sorts of issues in depth, situations that come up, 10-day letters, all sorts of things in depth. And I pray that you all have a joyous and prosperous year helping others with your real estate needs. And I also pray, dear Lord, that I did achieve my goal and that I was a reflection of your good and your glory and your peace, and that this time has blessed you guys, so that you may bless your public. I will stay on, please, as many of you are doing, your name, your license number, email address in the chat. Because everybody is going so quickly, feel free to unmute yourself if you do have a question, and I will be happy to answer whatever questions anyone may have.
Amazing class as usual, Dana. You did an amazing job.
Oh,
it's not long enough. Not long enough, because I know you could have even more than that.
I appreciate that. This is my first time teaching this class. So, the first time teaching, the first time you do a listing presentation or change it or a buyer's presentation, your timing is a little. So I just wanted to make sure I got everything covered. I took some good notes based on some of your questions and comments. I always encourage every agent, read your contracts from cover to cover. Something might not be new, but it hits you differently. Something might be new, but it's always a great idea. These are the tools of your trade, and you want to be familiar with the tools of your trade. Thank you
Dana,
so much.
Dana, I just wanted to explain to you why I was late. I
Yeah,
started
I
getting,
don't, that's okay.
okay, thank you. Thank you
Yeah,
very much.
yeah, you're good.
Have a blessed day.
You too, Laura. Thank you. Anybody else?
Going back to the disclosure statement, Dana,
Okay.
um, the way that they presented that, and I don't have my notes here in front of me to be able to specify, but if you check no for unknown, that opens a big, huge can of worms. Am I misinterpreting what you said? Or, I mean, because if I say no, that there's not, I know of no defect, but actually I don't, one is no, there is none, and one is,
You don't
do
know.
you see what I'm saying?
Yeah. So the disclosure statement, I think that had always been the implication is if a seller says no, that it's either no, I know for a fact this does not exist, or no, I have no knowledge. It might exist, but I don't know. If there is a leak in my crawl space, it might be there, but I have no clue about it. I don't ever go in my crawl space. It might be a slow leak, so my water bills aren't something. It might be there, but I have no knowledge. So in the disclosure statement, it had said it had already been pre-printed that a seller saying no means no knowledge. What they've added, that little section they've added for 2026 says it really means no or no knowledge. It's a fine distinction. I imagine there's some legal reason for that they've added that in. Basically, it's sort of to give the buyer a general idea of what the seller knows or may know about their house. And, we've got some sellers that have been in their houses for 20 years. I don't remember everything. I've got no clue. But uh, caveat emptor is the law in Georgia. And a lot of buyers need to understand this is a general guideline to give you a sense. If the seller said something, maybe you want to get a roofer, maybe you want to get a structural engineer, maybe you want to get a something. We've got a comment that I usually leave, Grace is saying, I usually leave no blank in the comment box below and write unknown. I have seen a lot of agents, a lot of sellers. Grace, you mean your sellers, not you. I have seen a lot of sellers because when GAR a few years ago took out that unknown,
Exactly.
add that in. So yeah, it's really tricky. Yeah,
Okay.
I hope you feel better.
Thank you. I'm gonna go nap now.
Any other questions?
So how long do you think before they change that stupid rule about having two people on this listing agreement?
I,
Because two companies cannot put the same.
that was
Oh,
I will tell you that one form prompted probably 30 minutes of discussion at the class I took at GAR, which is all brokers, attorneys, instructors, directors of schools, as well as many of the members of the GAR Forms Committee. And it was, I think brokers just need to decide if they're going to use it or not use
no.
it. Yeah,
No.
it's tricky because there's liability. Well, who did what? Who took the liability? Well, you said you were gonna do this, you didn't do this. I think as we discussed, and McKay actually brought up, I think that situation
It's going to be
is
rare.
probably, well, I don't think it's necessarily
I don't
rare.
think-
I think it's better handled with a broker to broker referral agreement. In the example I gave, let's say I'm an active agent and you're an active agent, but you live in Stone Mountain and I live in Woodstock. Well, I might have somebody that I know, love, and trust that's moving to Stone Mountain. I don't know anything about Stone Mountain, but they know, love, and trust me. They're like, I want to work with you. And I'm like, can't service you well. I'm not going to give you, but I've got this amazing agent that I know will. And usually in those situations, you do a broker to broker referral. Well, I think this form
Covers
could
that.
potentially be used in that situation. It kind of makes intuitive sense. Well, I want the client relationship so I can tell the public, my public friend, what's going on with respect to the contract. I want that information because of the communication based on that creating a client relationship. You want the client relationship because you're going to be working with that person to help buy a house. So I kind of understand that based on a relationship, but from a liability and a practicality, it becomes really, really, I'm sorry, this
Nightmare.
would be a listing agreement. So same scenario. So maybe this, okay, I've got a question. Same scenario, independent brokers with their own company goes on vacation, agent with another brokerage manages their listing while they're gone. Yeah, still
Yeah, how
tricky,
do you
but
put it in the system?
only one can put it in the system. So the
Yeah.
brokers have to decide.
Okay, well, Dana, in that scenario, say I'm working in one MLS and the other agent is working in a different MLS that also um, services that area. And by having both of the brokers, the one that is in that other area can list it in that MLS where I can't.
Yeah, that's a
Is that
great
That's a
thought.
great
That had not
thing.
occurred to me. That's a great thought, McKay. If
Until
it's
you
a
get to
property, yeah, if it's in
realtor.com.
an MLS I don't belong to, that could be you could do it that way. Yeah, that's brilliant. You're brilliant, McKay.
that's what you pay me the big bucks for?
Yeah, no, you know what? I love that because if there's a property like you've got people, let's say I've got somebody, let's say you live here, but you've got a vacation property up in the mountains that you want to list. I can't service you there. That you are, I'm going to write that down because that is really a great, wonderful use of this form where, I would list it here because there might be people here that also want a vacation house. And you would list it there because you belong there. That you are brilliant. That
And
is a
still going to be a problem when you write up that contract with those two different MLS numbers.
I don't think
well,
so.
the MLS number isn't that vital to the contract, though.
No, it isn't, but it is going to be a
Well, you just identify or who gets paid. Well,
Do-
both MLSs will get paid, but
exactly.
you would just spell that out. But that is a wonderful
It's a wonderful idea.
appropriate use of this form.
And Dana, based upon what someone just said, that means that also it's beneficial for awards and different things of that nature. Because if it's in the MLS, you get one type of credit versus it's just a referral.
Oh, awards, yep.
Yeah.
Yeah, for
Yeah, you gotta
awards, for
split
end
that
of the year
too.
volume awards, listing awards for the boards. Yep,
Yeah.
It's going to get
yep,
split also again. So
yep.
not half, third.
And the other, yeah, if you're in different boards, and the boards are going to have to deal with that. So that's a good point too. But the other appropriate use I see is, again, there are a lot of companies that basically are under one roof, one sales meeting, all the staff are the same, but on paper there's a realty company and a realtor company, and you might have two agents that, it could be like a mentor mentee situation or something, but they're in two different on paper two legitimately different companies, but they're working together. So I could see it, that would be much easier because you're still one management type situation that could be handled. Those are the two really good uses that I see for this. Other situations, I totally see a broker to broker referral handling these situations much easier with fewer headaches. Not no
Did
headaches,
they
but fewer.
explain? Did they give any explanation why they presented the form at the train the trainer?
No,
Was
there
there
were
a
there were a
scenario
lot
that
of experienced commercial agents that said it's why apparently more frequently used in commercial, and that's why.
Oh,
Oh, in
so
other states. Okay, Lorraine. Yeah, and some actually did say there it's handled. Thank you for reminding me of that. That this is in other states as well.
well, you've had people ask, can I have an agent from another company do an open house for me? So I guess this is just an extension of that as well.
That was brought up too, but I don't see that as a good use of this form, because you do have agents, but I don't want an agent hosting an agent from a different company. If somebody came to me uh and asked me as a broker for one of my agents holding an open house for another company, first of all, that's weird. Uh, from company to company, but I'm not going to agree to that. There's too much liability issues and too much payment issues. I'm not going to agree to that for an open house. But that discussion was raised at the class as well.
I see it the same way you do, but I'm not going to allow this form.
Yeah, there you go. You don't have to.
No.
California.
Much.
Okay. All right, everybody. Thank you so much. Blessings to all of you. I appreciate your time. I am blessed and honored and humbled that you guys took this class. And again, I defer you to your own broker, but you are more than welcome to reach out to me as an instructor, and I'll be happy to answer any generic instructor type of questions. Thank you guys so much. Yes.
I want to get with you anyway because I want to take some classes to teach.
All right. Awesome. Happy New Year, everybody.
No.